We're speaking to senior advocate Aman Lekhi about the statements that have been made by the Chief Justice of India, BR Gavai, recently. Sir, the CJI has clearly said that it's the Constitution which is supreme. What's your take on the statement, especially considering that recently we also saw a statement coming from the Vice President stating that it's the Parliament which is supreme and the elected representatives are the ultimate masters?
Well, those who frame, like the Vice President, this debate in the sense of superiority and subordination betray a complete misunderstanding of the way in which our legal system is organized. The occasion for the Vice President to have said that is the general assumption that the Supreme Court basically passes binding judgments which require compliance, often at not in conformity with what the politicians believe law should be. The point which is missed here is that in our system, no institution or organ is supreme, neither the Parliament, nor the Supreme Court, nor the Executive. That is unknown to our constitutional polity. The role of the Supreme Court is as an expositor of the Constitution. That is, it's a designated role of interpreting the Constitution. There has to be a body which has to interpret the Constitution. And because the Supreme Court interprets the Constitution, what it declares is actually law, as much law as the laws enacted by Parliament are. But the beauty of our system is that even the Supreme Court, when it declares the law as an interpreter, does not have any absolute power, much like the Parliament has got an absolute power. And why do I say so? Because the Supreme Court is bound by precedent, it's bound by the text of the Constitution, and it's bound by principle. But if you know and would be aware that the Supreme Court can overrule itself, and the Parliament can also legislatively overrule the Supreme Court by changing the basis of the law and bring about constitutional amendments. So the whole scheme, as has been devised, suggests, as the Chief Justice correctly points out, that what is actually supreme is the Constitution. Because it is in terms of what the Constitution mandates that each organ of the government functions. And no body under the Constitution can assume to itself the absolute and unquestioned power or claim any omnipotence. The suggestion that the Parliament is supreme is ill-suited to India, which has a written Constitution. It may be a bit more appropriate for the United Kingdom, which doesn't have a written constitution. And I feel that the occasion for the comment is merely an element of dislike for the counter-majoritarian and the controlling aspect of judicial review, which checks any kind of excess in any authority. So our discomfort, disinclination to accept a role doesn't necessarily mean that those who are expressing this displeasure are supreme. As the Chief Justice says, the Constitution is supreme.
So we've often seen the Supreme Court being criticized for its verdicts, the most recent one being its verdict regarding setting a time frame for governors to give their assent to the bills. Now, so the CJI has also said that only passing orders against the government doesn't decide that a judge is independent. On the other hand, he's also said that a judge cannot be affected by what public or what people have to say as far as their judgments are concerned. Do you think this is a response to the ongoing criticism, to public perception, or maybe a reminder to the judges?
No, you see, let's frame it differently. You picked up one instance where the Supreme Court has done something which a point of view suggests that's incorrect. I don't share that point of view, but that's for a different interview. Please also note that when the Supreme Court has actually functioned, the Supreme Court has at various points of times affirmed and accepted various constitutional amendments which are of significant importance, including, say, 4A and 4B of 16, or 5 and 6 of 16, or bringing in the chapters in the Constitution relating to the cooperative societies, etc., each of which has been challenged. That means what the Parliament has done has actually been affirmed. So it's not as if the Supreme Court is sitting there to strike down everything the Parliament does. What the Supreme Court does is, to the extent what the Parliament does is contrary to the constitutional principle, it strikes it down. And to the extent it is in consonance with it, it affirms it. Now, coming to the example which you gave, now, as far as the adjudication is concerned, the adjudicatory aspect cannot in any way be disconnected with the reality and the pragmatics of the situation, because as far as the adjudication is concerned, it's supposed to not just settle the norms, but apply them to the peculiarity of the situation. In the peculiarities of that situation, considering the way in which the governance was resulting in maladministration, something which was unconventional, but nevertheless judicially sanctioned, doesn't necessarily suggest that what was done is wrong. There may be a difference of opinion about what the Supreme Court does. Now, even in that case, the Supreme Court acted within the realm of its constitutional authority. There can be two views about whether the Supreme Court did it right or wrong, but you cannot say the Supreme Court transgressed its authority, and nor can you use that as an occasion to say the Supreme Court is claiming itself to be supreme, because even in so deciding, the Supreme Court affirmed what is a fundamental constitutional principle.
So lastly, this face-off of sorts where we see statements being made by executives, face-off between the executive and the judiciary. We've seen it happen on different aspects, different topics, be it appointment of judges, to Supreme Court's verdicts, to now of over whether Parliament is supreme or Constitution is supreme. So why do you think this happens so much, and what do you think is the solution? Because doesn't our Constitution and our law very clearly lay down which organ has what responsibility?
There's nothing wrong. We are a democratic polity. It's good to have difference of opinion. It's equally good to express difference of opinion. It's good to be exposed to different points of view. It's good that we have a contest of ideas that place. I believe the Parliament is not supreme. The Vice President thinks to the contrary. But both of us express ourselves. And we express ourselves in a manner which is appropriate to the occasion in which we talk. This is the beauty of Indian democracy. You cannot possibly use that to say that because there is no conformity, therefore there is a problem. The problem would be conformity. So this is a celebration of the diverse viewpoints, all of which are given adequate room for play in a polity. And far from showing some element of disquiet at what is happening, I think this shows the maturity of our system, that we can express ourselves with complete freedom on matters which are of importance, discuss and debate, and eventually resolve in a manner which is appropriate to find the solution to what may seem to be a problem. But I don't see a problem at all. Whatever the rhetoric of those in power may be, and the grandstanding anyone may do, something which is irrefutable is that in our system, if anything is supreme, it's the Constitution only.
Thank you so much for speaking to us, sir. That was Senior Advocate Aman Lekhi speaking to India Today on CJI's recent statements with camera person Alok Kumar from New Delhi. This is Srishti Ojha for India Today.